Cannon, you really are having problems without a. No, you don't have to explain.
I did ask the other attorney if there was anything in addition to what he had provided me. He said no, but I'm getting information from Mr. So that's fine.
Who said no?
We'll work it out about
Who said no? Well, you're just ignoring me now. You're not even talking to me. I'm not here to embarrass you. I will, but I'm not. You know what? She's not even attention, not even paying attention. Not even fine. No, you're not. I'm done with you. Oh, who's that? How are you?
How are you?
We'll see. All right.
We've been successful topic reporting the Office of the Public Defender. While people don't believe it's a conflict of decision, we're going to follow it.
Mike Gaddy, Assistant Public Defender on behalf of the Public Defender's Office, Your Honor. We concur with the people that we do not think any conflict exists. To the extent any conflict does exist, we would waive.
The court, for its part, also does not believe that there's a conflict either under Michigan court rules or the case is decided. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Michael Bank.
Good morning, Your Honor. Jacob Kennedy, on behalf of the people.
Good morning.
Your Honor, Michael Gaddy, Assistant Public Defender on behalf of Mr. Bank, who is with us via Zoom. If you could state your name, Mr. Bank.
Michael Bank.
Thank you, sir.
Your Honor, I'd ask the court for maybe a 2-week adjournment in this matter if the court would deem fit. I did meet with Mr. Bank via the video visitation method from Oakland County. It's I believe that given the nature of this file, we need to meet with him in person. It's time limited and the sound isn't very good.
All right. Any objection?
No.
Probable cause conference, April 30th, 2026, 9 a.m. Bond continues.
Thank you. I'll come visit you, Mr. Bank.
Mr. Bank.
Okay. Appreciate it, Your Honor.
Court does call the case. People versus Deshawn Gainey. Gainey.
Yes, I'm here.
Yes, I got you. I'm trying to get your attorney to give me an appearance. Hang on a second, sir.
Joy Gaines, Assistant Public Defender. Good morning, Your Honor.
Mr. Gainey, can you state your name, please, sir?
Deshawn.
Thank you. All right, what do we do?
Your Honor, at this time, at this time, we would ask for an adjournment so that we could make arrangements to meet with Mr. Gainey in the Department of Corrections.
Yeah, is there going to be a problem with JCF in terms of getting in to meet him, or?
I would ask for 3 weeks. I have not worked with this facility yet.
Probable cause conference without objection will be adjourned May 7th, 2026, 9 a.m. Bound in this matter will.
Michelle's case again.
Thank you. And I'll need a green sheet.
Yes.
Thank you, Mr. Gaines. Court does call the case, People versus Ryan Milligan.
Assistant Public Defender representing Mr. Milligan. Your Honor, I've had an opportunity to discuss this case with Mr. Milligan, as well as with Ms. Cinda and the circuit court attorneys who will be handling his case before Judge Slay. At this time, the prosecutor has agreed to a sentence agreement upon a successful plea to guilty as charged. Mr. Milligan they would agree that Mr. Milligan's sentence would be credit for time served, no additional incarceration. In talking to my colleagues in circuit court, we're going to waive that in order to secure that also with Judge Slay and are asking for a pretrial date.
That's correct, Your Honor.
All right. Mr. Milligan, you're gonna waive your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir, Mr. Simpson.
All right. People also waive their right.
Thank you, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client will stand mute and enter a not guilty plea.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter,
April 30th at 1:30 is Judge Slay.
April 30th, 2026, 1:30, Judge Slay.
Thank you.
Thank you.
And will continue. Thank you, sir.
Thank you, Mr. Milligan.
Thank you.
Yeah. Court does call the case of the person. Chidra. Hold on. Aikiji.
Good morning, Your Honor. Any of the people?
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji for his case ending in 1678.
And
Mr. Ikeji's coming out now.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ikeji on all the remaining matters, Your Honor.
All right, what are we doing?
Your Honor, may we request, and it's for all four cases, a 1-week adjournment. When we were here last time, we had thought and the prosecution had agreed to a mental health court disposition. Unfortunately, between now and then, he was not accepted into mental health court. And so we are working out what we hope will be a HIDA disposition, but we need 1 more week just to figure everything out.
Is everything going to be able to be figured out in a week? I don't want to get here in a week and then be adjourned again.
Your Honor, I'm optimistic that we will get there in a week.
I appreciate your optimism. That doesn't answer my question.
I do think we're nearing a resolution. We have several matters that we're trying to sort of get together in one big global.
We about to tear.
I know. What was that? Oh, okay, never mind. I just thought all in this with us. Mr. Bellinger, do you think a week's gonna do it?
Your Honor, I do. Based on our conversations, it sounds like we may be waiving everything up as early as next week. So I believe a week would be just fine.
Probable cause conference, April 23rd, 2026, 9 a.m. Bond continued.
Your Honor, could I ask to address bond?
Yes.
So it's been over 180 days for Mr. Ikeji. Certainly, if it's a HIDA disposition, that's more time than we would expect to see there, significantly more time. He is doing extremely well. Mr. Bellany and I have both observed the changes since we first met him several months ago and where he is now, as has the Forensic Center with their prior evaluation, their more recent evaluations. There actually is a finding there of not guilty by reason of insanity if he were to pursue that route. His family is extremely supportive. Both his mom and his dad are here today. And I'm confident based on my meetings that he would do well on our request is home confinement. He would continue to get the medications he's getting. He'd work with community mental health services. And due to the amount of time he spent and how well he's doing, that's our request.
Anything else from anybody else?
No, it's for court.
No, Your Honor.
All right. I won't say I won't consider it next week, but I'm not going to do anything now. Motion for bond reduction denied.
Thank you.
Court calls case People versus Allen Folks.
Ashley Feltus for the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Folks, who is in the courtroom.
Yes,
And good morning, Miss Barnwell. Long time no see.
Yes, Judge.
Your name, sir?
Alan Folks, Your Honor.
All right, what are we doing on this case?
Your Honor, I'm requesting a preliminary examination. I do have
right.
electronic and paper discovery.
All right, thank you. My date is the
April 28th.
People also, will they have your witnesses available on the 28th?
Try for that date, Your Honor.
Preliminary examination in person for 28th, 2026.
Your
9
Honor,
a.m.
I do have, sorry about that. I do have
I should have known.
another. Well, it's in downtown Ann Arbor, but I think I could zoom on that one. I think so. That's a sentencing.
Oh, you've got
1 second.
something in downtown Ann Arbor that you think you might
Yeah.
need to zoom in. Okay,
I'll zoom
think
into
we can-
that one, but I'll come physically in for this one.
all right, very good. 28th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond continued. Thank you.
Same courthouse, Mr. Folks, same courthouse.
This
We'll
one.
talk. Thank you, Judge.
said
Have a good day, everybody.
All right, you do the same, Ms. Barton.
Yes.
Court does call the case, People versus Devon Thompson.
That's the focus for the people.
Morning, Your Honor. Marcia Krejci on behalf of Mr. Thompson, who's approaching.
Your name?
Devon Thompson.
Thank you.
Your Honor, we have two requests today. The first request is we'd like to proceed to preliminary exam. I believe discovery is complete. We have a sort of a special thing in mind that,
That's correct, Your Honor. The defendant's co-defendant, Devon Henning, is already set for preliminary examination on a special setting before Judge Freshour. And I would request. that-
Okay, what date is that?
It's April the 29th at 1 p.m. at the 1484 District Courthouse.
That's the co-defendant to this case.
That's correct. And
Fresh hour, know it's coming.
I believe so. I was emailing with Ms. Ostrowski yesterday about this.
that date came about with the meeting that we had, with Judge Freshour.
All right. And I'm presuming then the people would have their witnesses available.
We'll do our best, Your Honor.
All right. Preliminary examination, April 29th, 2026.
These
What,
tech-
good at
1 p.m., Your Honor.
1 p.m.
The second request comes from my client. He would like me to address bond briefly.
Go ahead.
My client stands before you, a young man who was 17 when this incident allegedly occurred. I believe his criminal history at the juvenile is pretty, I think he's got a CCW, if I'm not mistaken. But after that, there's nothing else. He does have family in the area. He's resided here his whole life. He explains to me that he'd be able to currently reside with his grandmother in Ypsilanti, and that he is needed to help with childcare of his younger siblings. And so he's asking that the court allow him 10%. If the court does, we'll be asking for a PR bond in this matter. He'd be willing to do a house arrest on tether. That's our request today.
Your Honor, the defendant was involved in the planning and execution of an armed robbery where the item to be stolen was a firearm or firearms. The defendant has 2 firearm-related charges, CCW and reckless use of a firearm while a juvenile in 2025 and 2024 respectively. In this case, a victim and a co-conspirator were both shot. So I do believe the cash bond as that is appropriate.
So 2 people got shot in this whole ordeal. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Aaron Brandon.
Alexander on behalf of the people.
Burdell on behalf of Mr. Brandon, who should be appearing by Zoom. Oh, Mr. Brandon.
Aaron Brandon.
Thank you. Here we go.
Amended. This should have been charges on a monster offense rather than prepared a. Terms of direct domestic violence charge. Then I'm intending to move to dismiss count 2, the defendants are reigned on or add the count 3 of the tower domestic violence charge. And I did send that.
Any objection to that, Mr.
No, Your Honor.
This time I will dismiss count 2. We will do the arraignment on then the count.
Stand mute, waive formal reading.
All right. Gonna waive formal reading and standing mute for will enter not guilty, please.
As to the probable cause conference today, just asking for an adjournment. I was just appointed very recently. I have my green sheet here for to hand to your deputy.
Probable cause conference will be adjourned to May 7th, 2026 night.
Right. Which
Bond continues. Thank you.
especially don't know.
Court calls case People versus George Wright.
Chavis and on behalf, Your Honor.
Moving on to Marshall Page on behalf of Mr. Wright, who's approaching. Bless you. Bless you again.
All right. Your name, sir?
George Willis Wright.
Thank you.
Your Honor, we'd be requesting a preliminary exam in this matter.
You have all discovery.
Yes, I do, Your Honor.
Your other witnesses available the 28th. Preliminary examination person at the 28th, 2026, 9 a.m. before me.
Your Honor, my client is asking me to make a request to for a PR bond, if I may, briefly.
Briefly.
So, Your Honor, my client stands before you. His last convict leave for any crime was in 2024. Further, most notably is my client has some health issues that require some surgery. The first one is some eye issues that require surgery at the Kellogg Eye Center, which he tells me he has surgery scheduled for April 20. Is that correct?
Yes.
Okay, and that he also needs to follow up with a surgery in his abdomen that requires follow-up. He has been able to secure housing at Miller Manor that so he has no family there in the area to help him. Therefore, he needs to be out and about. Specifically, he needs to be able to get to his bank account for bond. What I'm being told by my client is, if the court is unwilling to reduce the bond, is that his phone privileges have been prohibited. I don't know if that's true or not, but because I haven't been able to research that through the jail, but he's asking to have phone privileges. So if the court is unwilling to give him a PR bond, then the court would be, he can then make arrangements with a bail bondsman.
Wrong.
Your Honor, at this time, the people are going to be objecting. This is the case. Was strangled by the defendant to the point of unconsciousness and wants to share the defendant or I'll kill you, bitch. He has a very lengthy history of domestic violence, including a DV conviction in 2010, 2 FAs from 2015, a DV conviction from 2019, and ongoing aggravated DV from 2019 for the 2023 domestic violence conviction, along with the dismiss DV for 2025. So at this point, I'm objecting. As to the phone privileges, I don't recall that being revoked. I don't believe that was the trust at arraignment. So
I don't see that. I ordered it. So I don't.
Right. My client says it's from a previous incident case that it was convicted, but if it is, then I guess a stipulated order from the court.
I'm not stipulating any. I don't know why they're revoked. It may be proper that they are revoked because I had contact the victim. So I'm not going to agree to anything regarding that. You can talk to the prosecutor about that. And
All right.
I'll
All right.
with it, but I'm not agreeing. I want to make it clear. I'm not agreeing to restore anything.
Sure.
Motion for bond reductions denied. Bond will continue.
Thank you, Your Honor. Bond reduction denied.
Court calls the case People versus Robert Laster.
Ashley Feltus for the people.
Kyle Burdell, excuse me, Kyle Burdell on behalf of Mr. Laster, who's approaching the podium.
Michael Gainey on behalf of Mr. Laster, 23 F 1486 and 1117.
Just attorney and a bond argument and a bond request.
How you doing, Justin?
Your name?
Robert Laster, Justin.
Doing?
Your Honor, on my case, at least, and it's my understanding, based on what's in Mr. Gaddy's hand, we are both asking for adjournment at this time. I do have a bond request from the court. Would like to hear it.
That's correct, Your Honor. I think it'd be prudent to keep all three together.
May 7th, 2026, 9 a.m. Esteban.
Your Honor, Mr. Laster.
May I approach, Judge?
Okay. Sorry, approach. Oh, is it just a hand on the
Just a
phone?
hand in the.
Oh, sure. Your Honor, as to the bond request, so Mr. Laster lives in Mississippi. He's currently basically couch crashing with a friend. And so his bond has already been modified from community corrections, or his community corrections already has instructions to allow him to test locally where he's at. But at this point, it's my understanding that he does not have permission to leave the state. So we just ask that he be allowed to return to his family. He has a 10-year-old daughter and an 8-year-old grandson back home in Mississippi that he needs to get home back to and take care of.
So first thing though is that he corrected the community corrections violations.
That is correct, Your Honor. He went and tested this morning. I spoke to him.
Thank you, Justin.
I went and spoke to him yesterday. He called yesterday before duty. Then immediately after I informed him of the issue.
And I'll echo the same as Mr. Gaddy. He was very apologetic and Mr. Laster was very apologetic and eager to correct his misstep and his oversight.
Response from the people.
Your Honor, Selton has gotten he did his initial test. I don't know if we have those results yet. If it was just this morning, that would be something I might be interested in.
Before
we
any agreement.
Yeah, just because there was that bond violation, not going to test for almost a week. Maybe a week, actually, now that I think about it, it was the night.
Motion for bond modification. All right, bond will continue as it's as you can't leave the state.
Understood.
Thank you.
State your apologies.
7.
Thank you.
Oh.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Tanisha Moore.
People, Your Honor.
Perfect. Kyle Burdell standing in for attorney of record Bill Amadeo on behalf of Miss Moore.
Your name?
Tanisha, Moore.
Objection to Mr. Burdell stepping in.
Standing in on behalf of Mr. Amadeo today.
Oh,
Is that all right?
that's true.
No? All right.
No objections. Thank you. So, Your Honor, at this point, it's my understanding that the parties are working on a resolution. I have the green sheet for your deputy.
Probable cause conference will be adjourned without objection to April 30th, 2026.
Thank you, Judge.
Bond continue.
Bill will be in much.
Okay, thank you.
Thank you.
Court does call the case People versus Lewis McSwain.
Ashley Feltus for the people.
Kyle Burdell on behalf of Swain, standing in for attorney of record Bill Amadeo.
Be here.
I don't believe he is, Judge, unless he's on Zoom. Mr. Amadeo has been attempting to contact him, but I cannot explain his absence here today.
Swain. On bench warrant will issue for defendant's failure to bond is set in the amount of $10,000 cash shirt. Will issue immediately.
Understood. Thank you, Judge.
Court does call the case for People versus Walter Rice.
Your Honor.
Brilliant.
Trees. Mr. He's Ostrich. Three from the bottom.
All right. Counsel for defense state their appearance. We don't have him here anyway, right?
Okay.
Pass this matter.
I'm sorry, I'm here. I'm filling in for Attorney Max Dubin.
Do you know where your client is? We don't.
Yes, he's in custody.
Okay.
And I did not see them on Zoom.
You're right. But he's not here. We don't know where he is. Is that right?
Yes, that is correct.
He is in custody in Macomb County Jail.
Oh, wow, that explains it. He's not in custody here. He's in
Correct.
Macomb.
Yes, so he should be on Zoom.
No, because I don't think the writ was done. No writ was done because we did not know that he was located in Macomb County.
Okay.
So I will adjourn the probable cause hearing. Do you know how long he's intending on being in Macomb?
I do not.
I'll adjourn the probable cause hearing till the 30th, so the writ can be prepared and then we'll proceed from there.
Thank you so much, Judge.
2026, 9 a.m. bond continued.
Thank you, Judge.
Thank you. Court calls case People versus Justin Chavis.
Yes, Your Honor.
The AGs. Oh, there she is.
Good morning, Your Honor.
Good morning. State your appearance, please.
Carrie Angie on behalf of the Attorney General's office.
Thank you.
And Stephanie Canna on behalf of Mr. Chavis. And I believe you by Zoom.
Chavis.
I don't have an intern anymore.
I know. I wasn't used to hearing your voice.
It's gonna be me.
It was a pleasant respite.
It was respite.
All right.
Could you please state the name?
What's it?
I think
Harvey?
you said it. You're
Yeah, what's your name?
Justin Chavis. Sorry, the sound is so choppy right now. It's hard for me to hear.
Okay, no, it's okay. You're good. It's your attorney.
It is. It 1000% is. And Your Honor, we are asking for an adjournment. I did receive the offer yesterday, but we still don't have discovery, and I will get you a green sheet. Again, I don't have it.
You don't have a green sheet?
I don't have an
You
intern.
don't have an intern? You don't have a green sheet?
I know.
You don't know how to do anything.
I'm struggling. I'm struggling.
Baby.
Without objection, I'll adjourn this to April 30, 2026, 9 a.m.
Thank you, Your Honor.
All right, bond will continue. Set it for the AG.
Thank
That's
you, Your
it?
Honor.
Thank you. Have a great day.
Likewise.
Court does call the case. People versus Kurt Bushline.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Bushline.
Your name, sir?
Kurt Bushline.
Thank you. What are we doing?
Your Honor, I believe, have a plea in theory. I just didn't receive a form for Mr. Chebalowski, who is not present today. I know Ms. Feltis was covering it, and we were emailing last night. It's to plead a use, Your Honor. I just didn't get the form.
You. Ms. Feltis, I know you're trying to cover a lot, so
I
I
wasn't
get.
clear on that from our email exchange that we were doing the plea today. So I apologize for not understanding that accurately. So I would request an adjournment of 1 week so we can get that done with the court's grace. Thank you.
I'll adjourn it out 1 week. April 23rd, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Ms. Feltis.
Court calls case People versus Rashad at your Harshik. Best I could. There's a lot of letters.
Agreed. Ready, Judge. Torshel Feaster, Assistant Public Defender on behalf of my client. Please state your name for the record.
Good try. Okay. Go ahead. What's your name, sir?
Adarazzic. Adarazzic.
Yeah, what he said.
Okay. No. All right. What are we doing?
Thank you, Judge. The last time we were here, I believe my client was in custody in a different county, and so we weren't able to address the matter, but it's been resolved now. So this is our first real PCC.
Got it.
On adjournment, Judge, so we can talk to the client and the people and see about a potential resolution.
Probable cause conference. 7th, 2026, 9 a.m. Bond on this will continue, and you don't have a green sheet because Cannon was supposed to do it, right?
Too much.
Okay.
All
right. Oh, we'll wait. All right. Thank you.
Thank you, Your Honor.
In touch.
Court calls the case. People versus Jason Bryant.
Morning, Judge. Brian Bowling on behalf of Mr. Bryant. How you doing? Can you take the record, please?
Jason Bryant.
Thank you.
Judge, we're asking that this matter be set for an examination. I believe all discovery to be complete.
People have their witnesses available the 28th.
Your Honor.
Preliminary examination in person, April 28th, 2026, 9 a.m. before Judge Barber. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of this versus John Allen.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Allen.
Your name, sir?
Dion Allen, sir.
Thank you.
Your Honor, we are requesting a preliminary examination, and we are also would like to address bond condition.
Discovery is complete.
That's my understanding.
People have their witnesses available 28th. Preliminary examination in person, April 28th, 2026, 9 a.m. before me. As the bond.
Your Honor, it's my understanding that Mr. Allen is on GPS tether. We are requesting either the removal of the tether or a change in the exclusion hot zone from the address. Based on, it's our understanding, and Ms. Mackey did reach out to Ms. Zinda to confirm that the complainant is no longer at the hot zone address.
No, she won't be at that address until, so I would be objecting to any modification of that until she is actually arrested.
Motion for modification is denied, given those circumstances. Thank you. Court does call the case of the people versus Kimberly Douglas.
People.
Assistant Public Defender Chelsea Virgil with and on behalf of Kimberly Douglas.
Hello, Ms. Virgios. It's been a while.
Good morning. It has. Please state your name.
Kimberly Douglas.
Good to see you, Your Honor. We are asking for an adjournment in this case. She has a pretrial in circuit court on April 23rd, so we ask for a date after that.
Okay. Probable cause conference without objection, April 30th, 2026, 9 a.m. Bond continued. Thank you. Court calls case people versus Malik Asadi. I was close.
Good.
All right.
That's like you said perfectly.
Yeah.
Stephanie Cannon, on behalf of Mr. City.
That's exciting.
All right. I have before me a plea form that indicates that he's going to plead guilty to the charge of disturbing the peace of 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of it.
Yes, Your Honor.
Yes, Your Honor, that is my complete and full understanding.
May I have him sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so nothing but?
Yes, sir.
Name, please.
That's exciting.
All right. Put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days, $500 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Good.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see that copy shot on the podium, the rights which are part of a trial. And by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
Then you're giving up your right to appeal upright.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes.
On the date of September 14th, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washington County, State of Michigan, were you out in public?
Yes, Your Honor.
And was there a disturbance?
Yes, Your Honor.
Okay, what happened?
We're out of a bar and we're all with friends and stuff, and we made a lot
of noise.
Yes, sir.
And that it disturbed the peace and repose of the area immediately surrounding you. Sir, if I accept your plea, I do have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor. I'm aware of none, Your Honor.
And have I complied with the court rule?
I'm satisfied, Your Honor.
Yes, Your Honor, I'm satisfied.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
May 8th at 8:30.
May 8, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Russell Gus.
Justice for the people.
Good morning, Your Honor. Assistant Public Defender Davy Leave on behalf of Mr. Gal. Gal, can you tell the judge your name, sir?
Russell Gus.
And Your Honor, I'd like to set the matter for preliminary examination, please. Discovery is complete.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
You can track them, Your Honor.
All right. Preliminary examination will be set April 28, 2026, 9 a.m. before Judge Barr.
Thank you.
Bond will continue. Thank you. Court does call the case of the people versus Melinda Baker.
Justice for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Baker, Your Honor. He is here by Zoom.
Oh, there she is. Ms. Baker, can you state your name, please?
Melinda Baker.
Thank you.
Your Honor, may we approach very briefly?
Yes. Yes.
Why are they approaching? I don't like it.
Record should reflect we've had a brief bench conference in this case. Circumstances of this, I'll adjourn probable cause conference to May 21st, 2026, 9 a.m.
Your Judge. I'll be in contact.
Thank you.
Court calls the case, People versus Edward Harvey.
Ellie's on behalf of people, Your Honor.
Assistant Public Defender Duffy Luba on behalf of Mr. Harvey. Mr. Harvey, could you tell the court your name, please?
You can say it.
No, you need to say your name, sir.
Sir, what is your name?
Harvey.
Your full name?
Edward Harvey.
Thank you. What are we doing?
Your Honor, I'd like to set this matter for preliminary examination, please.
Yes. So discovery is complete.
It is not, Your Honor. We're still waiting on receiving some body camera. Harvey's indicated to me that he would not like to waive any time frames and would like to set this matter.
All right, but he understands also that if that does not appear, it's not going to be the basis for an adjournment.
He does understand that I did review those, Mr. Harvey.
We'll have their witnesses available on the 28th.
I did reach out to the sheriff's department about the body camera. I heard that, but I need to do a little bit more discussions.
Preliminary examination will be set April 28th, 2026, 9 a.m. That's before me.
Thank you, Your Honor.
As to bond.
Mentioned that Mr. Harvey has contacted a number that the victim is using 16 times from and how we know it's the number for the victim is she's referred to as his wife. He loves her, begging for her forgiveness. So at this point, I'm going to be asking for his calls and texts to be revoked. He talks about what might happen with the case, if they come to court, if they don't come to court. So at this point, we'll ask for his calls and texts to be revoked.
That's any response.
No, this is my first time hearing about this.
It's not too hard. Well, we'll get that to him. And at this point, I'm going to revoke the defendant's phone and texting privileges from the Washington County Jail. Right. Thank you. Court calls the case, People versus Shelby Barber.
People, Your Honor.
For the judge, court shall cease to assistant public defender on behalf of Shelby Barber. Please
Your
take.
name?
Shelby Barber.
Thank you.
Thank you, Judge. According to our notes in the file, it looks like we are missing a second police report in this file. And so we're going to be requesting an adjournment so that we can get that second police report.
You know anything about that?
Yeah, Your Honor, my understanding is that the report is included in the media notice on this file, but I can route it different way.
It's a different. Okay.
Thank you so much. Appreciate it. Thank you.
All right, I will adjourn May 7th, 2026, 9 a.m.
Thank you, Your Honor.
All right.
Thank you, Judge. Be in touch.
Court calls case, People versus Larry Taseroo.
Brian Bowling on behalf of Mr. Taseroo, Your Honor. Can you state your name for the record, please?
Larry Taseroo.
Your Honor, I'm asking for a preliminary examination in this matter. I believe all discovery to be complete.
All right. People have their witnesses available on the 28th.
Well, Your Honor, there is one uncharged case, which I think will be a misdemeanor that's slightly related to this. So I'll work on getting that police report disclosed to defense before that date, just so they have absolutely everything. But I think as far as the four corners of this case, we do have everything disclosed. There's just one more thing I'll get over there. Right.
All right. That is my understanding. Thanks, Judge.
Preliminary examination, April 28th, 2026, 9 a.m. That's before Judge Barr.
Thank you, Your Honor. Thank you, Brian.
The court calls the case, People versus Manuel Barnthouse.
Here, Your Honor.
Stephanie Cannon on behalf of Mr. Barnthouse, who is appearing by Zoom for Barnthouse. Mr. Barnthouse, could you please state your name for the record?
Manuel Barnthouse.
Your Honor, we're just asking that this be set for a preliminary exam. Oh, and we also have to arraign him on the additional charge.
Yes, on the additional charges, counts 4 through 7. Have you gone through that with him?
Your Honor, I have emailed him the information and we discussed it. Yes.
All right. And so as to the arraignment on counts 4 through 7?
Your Honor, my client would stand mute and ask for his next court hearing.
All right.
And we would waive the formal reading.
Defendant standing mute, or waiving formal reading, standing mute. Court will enter a not guilty plea as counsel for the truth. I will wanted to set for preliminaries,
Yes, Your Honor.
right? Would you be ready to go with those amended counts on the 28th?
Your Honor, it's my understanding that paperwork, yes, they've already given me what they have regarding, and I'm not anticipating any additional discovery.
Your Honor, based on the nature of the new offenses, should counsel wish to view those prior to the examination, we would need to set up a meeting with officers. That's taking place. So I don't know if that's necessarily.
So that doesn't sound like discovery is complete.
Your Honor,
Want to do that sometimes. Doesn't want to do that.
I was provided with a packet of the download from your other counsel. If additional discovery has been created, please let me know.
And based upon the offenses.
Then yes, Your Honor.
And yes, Your Honor, what?
Yes, Your Honor, we'll ask for another PCC date.
That's probably wise. All right. Probable cause conference will be adjourned to May 7th, 2026. 9 a.m. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Cannon, you really are having problems without a. No, you don't have to explain.
I did ask the other attorney if there was anything in addition to what he had provided me. He said no, but I'm getting information from Mr. So that's fine.
Who said no?
We'll work it out amongst ourselves.
Who said no? Well, you're just ignoring me now. You're not even talking to me. I'm not here to embarrass you. I will, but I'm not. You know what? She's not even attention, not even paying attention. Not even fine. No, you're not. I'm done with you. Courthouse case.
This courtroom moment escalates fast as the judge realizes he's being completely ignored. It starts with a simple question, who said no? But there's no real response. The judge repeats himself, trying to get the lawyer's attention, but she continues looking away, not engaging. That's when the frustration kicks in. Well, you're just ignoring me now, and you're not even talking to me. The tone shifts instantly. Now it's no longer about the case, it's about respect. The judge makes it clear he sees exactly what's happening, calling it out in real time. The courtroom gets quiet as he leans in with a sharp warning. I'm not here to embarrass you. I will, but I'm not. At this point, the patience is gone. He points it out directly. She's not paying attention, not even trying to respond. And then the final line drops cold and controlled. I'm done with you. In just a few seconds, the entire room feels the shift. Because in a courtroom, ignoring the judge isn't just disrespectful, it's a mistake you don't come back from.